Hi, everybody. Welcome to the first webinar in this series on responsible prosecution. My name is Jennifer Doliak. I'm an economics professor at Texas A&M and a senior fellow at the Niskanen Center, which is hosting these conversations. The goal of this series is to bring evidence to the often heated policy conversation on the role of prosecutors in the criminal justice system, as well as the effects of various policy reforms targeting prosecutors' behavior. So our focus here is on research evidence that measures the causal effects of prosecutors and related policy reforms, that is, research that distinguishes correlation from causation. We have a fantastic lineup of top scholars who will share their work with you in short presentations with an emphasis on the policy implications. They have 10 minutes each, so we're going to fly right through here. And we're going to kick things off with Emily Leslie. So Emily, you can take it away. Oh, you're muted, Emily.
There we go. All right. I'm going to present work that I did with my co-author Nolan Pope on the effect of pretrial detention on case outcomes. Pretrial detention is the practice of holding people in jail while their case is being adjudicated. Pretrial detainees make up nearly a quarter of all inmates in the United States at any given time, so it's a large fraction of the incarcerated population here. Naturally, detaining this many people is expensive for local governments, not to mention the costs to the detainees themselves. It's been well documented for several decades that pretrial detention is correlated with less favorable outcomes for defendants. So people who are detained are more likely to be convicted than people who are released pretrial. The goal of our project was to figure out whether that correlation was the result of a causal effect of pretrial detention on case outcomes, as opposed to the fact that pretrial detainees are systematically different from people who are released in other ways that could also feed into their case outcomes. We studied this question in the context of the New York City criminal courts using 5 years of data on all felony and misdemeanor cases in the city. That's about 1 million cases. A quarter of them were felony cases, the rest were misdemeanor cases. In both of these groups, people who were detained were around 15 percentage points more likely to be convicted. Most of that comes through guilty pleas, so it's worth keeping in mind that very few cases in the US and in this setting go to trial. In our data, that's less than 1% of cases. So when we're talking about the effect of pretrial detention on conviction, this is going to be largely operating through whether detention induces people to plead guilty. Our strategy for estimating the causal effect of pretrial detention on case outcomes relies on the way the arraignment process works. When a person is arrested, their first hearing is an arraignment where they're formally informed of the charges that are being brought against them, and the arraignment judge makes a decision about what their pretrial status will be. They may be remanded without bail, or they may have a bail amount set where if they post, they can be released, and if not, they'll be detained, or they may be released without bail, perhaps with some non-monetary conditions attached. We're going to collapse that array of possibilities down into just 2 categories: people who are detained and people who are released. Now, the key for our strategy is that there are lots of judges who preside over these arraignment hearings, and they vary in their leniency towards defendants. So a defendant may be, by chance, arraigned before a judge who's relatively less lenient and detains a larger fraction of the defendants that come before them. Or they may, by chance, appear before a more lenient judge who releases relatively more defendants. Defendants are essentially randomly assigned to these judges, and this is the only opportunity that judges have to affect how the case goes, because other judges will preside over future hearings. So this creates a natural experiment that we're going to leverage. So we're going to basically look at whether defendants who appear before more lenient judges have systematically different case outcomes from those who appear before less lenient judges. And if they do, we're going to attribute that to the causal effect of pretrial detention. When we embed that naturally arising variation into a regression framework, these are the estimates we get of the causal effect of pretrial detention. So in both felony and misdemeanor cases, we see a substantial increase in the probability of conviction because of pretrial detention. All of these estimates are quite precisely estimated. They're significant at the 1% level. So for felony defendants, we find that pretrial detention increases the probability of conviction by 13 percentage points and 7 percentage points for misdemeanor defendants. Most of this is coming through guilty pleas, as we expected. And we also find that pretrial detention increases minimum sentence lengths. So across the board, pretrial detention results in less favorable outcomes for detainees. One possible motivation for using pretrial detention could be to prevent crimes that defendants may commit while their case is being adjudicated. Unsurprisingly, we find that when people are detained, they are less likely to be rearrested. On the other hand, we also find an increase in recidivism in the 2 years following adjudication. So most of that reduction in rearrest is offset by an increase in recidivism after the case is closed. We don't find evidence that the effects of pretrial detention are different for different groups of defendants by race, but it is certainly the case that Black defendants and Hispanic defendants are more likely to be detained than their white counterparts. So the effects of pretrial detention are felt disproportionately by defendants of color. We don't have the data or the institutional characteristics that we would need to figure out exactly what mechanisms are at work here, but here are a few possibilities that we think are plausible. It's possible that pretrial detainees are motivated to accept a guilty plea to reduce uncertainty about how long they'll be incarcerated. So just because very few cases go to trial doesn't mean that the experience of people who go to trial is irrelevant for decision making. That's the outside option for someone who's detained when they're considering whether to take a plea deal. And for that small group that does go to trial, we see large variation in how long pretrial detention lasts. So on the high end for felony defendants, we see people who are being detained for lengths approaching 3 years. For misdemeanor defendants, the lengths are shorter. On the high end, we're seeing something closer to 1.5 years. And it's worth keeping in mind that misdemeanors by definition cannot be punished by more than 1 year in jail. So you're talking about people who may face incarceration for longer than the maximum sentence they could receive if they were convicted. So it's conceivable that people might decide that they would rather take a plea deal, put an end date on their incarceration, rather than staying in jail for an indeterminate amount of time and facing the uncertainty of trial. It's also believable that it could be more difficult to mount an effective defense from jail, where people are less able to recruit witnesses who could testify on their behalf, et cetera. And finally, in New York City, as in many other settings, the time that people are detained counts against their sentence. So they're kind of paying the cost of any given guilty plea in advance, making it relatively cheaper for someone to plead guilty from the perspective of their time and freedom. So all of these are possibilities that could feed into why pretrial detention induces people to plead guilty more. I want to mention that there are a couple of other papers that have used similar strategies in other parts of the United States, and their results are consistent with ours. So this finding that pretrial detention causally results in an increase in conviction is well supported by multiple high-quality studies in the literature. So what are the policy takeaways? It's important, I think, for criminal justice actors such as judges and prosecutors to realize that when they pursue pretrial detention or higher amounts of bail, that they're having an effect on the case outcome. They may be inducing someone to plead guilty who wouldn't plead guilty otherwise. And that may not be the intended purpose of pretrial detention, but that is one of its effects. Given that not everyone is detained pretrial, naturally its influence is not going to affect everyone the same way, which calls into question the fairness of the system. There are good reasons why we don't detain everyone pretrial, and I'm not suggesting that we should, but I think that there may be cheaper, fairer strategies that we could consider to accomplish the same goals that pretrial detention has. I think among these goals are encouraging appearance at hearings, protecting public safety, and keeping caseloads manageable. There are, I think, innovative ideas out there for ways that we can accomplish the same objectives in perhaps ways that will not result in uneven treatment within the criminal justice system. And our analysis suggests that it's well worth thinking and analyzing whether those are feasible and effective. If you have any questions, please feel free to reach out to me by email. Thanks.
Great, thank you, Emily. And that is a great segue into Jens Ludwig's talk.
Great. Can everybody see my slides? So I'm Jens Ludwig from the University of Chicago. Thanks, Jen, for organizing this, and to the Niskanen Center for hosting. This is some work that I've been doing with a variety of computer science and economics colleagues. It builds nicely on Emily's terrific talk and terrific work. What I'm going to talk a little bit about is whether there are ways that we can use data to try and improve. So Emily just showed us something about the consequences of pretrial detention. Can we use data to improve pretrial outcomes? Will be my focus. It probably goes without saying for this audience how important the pretrial system is. Emily alluded to this. The thing that I wanted to maybe say in a slightly different way is just the vast number of people touched by pretrial. So in the United States, in a typical year, something like 10 to 12 million people get arrested. When people are incarcerated, the average detention spell in jail is on the order of 2 to 3 months. It can be as high as 9 to 12 months. At any point in time, we have 750,000 people in jail in a typical year. And I think as everybody is increasingly aware, these pretrial detention populations are very disproportionately drawn from economically disadvantaged Black and Brown communities. So super important public policy challenge, criminal justice challenge. Very consequential. And the starting point for our thinking about how we might potentially improve pretrial outcomes is the recognition that the law says to judges that when they're deciding whether to detain a judge or not, they're not supposed to be thinking about whether the person's guilty or not. They're not supposed to be thinking about what the right punishment is for the crime or not. I think as Emily alluded to at the end of her talk, the judge is supposed to be making a prediction about whether the defendant is going to come back to court or represents a threat to public safety. And so we've come to call a policy decision like this that hinges on a prediction, we call that a prediction policy problem. And in this particular case, the decision depends on the prediction essentially of a combination of both judges and prosecutors. As in most jurisdictions, the prosecutors make pretrial recommendations to judges, and then to varying degrees, the judges put weight on those prosecutorial recommendations. Okay, now, the interesting thing about this as a starting point for understanding how we might improve this problem is the recognition that there's a huge body of research in psychology dating back to the 1950s that tell us that human beings are terrible at making predictions. And it turns out that that is true in the criminal justice system as well. So this is a graph that shows on the x-axis here, predicted defendant risk. And on the y-axis here is release rates, okay? And what you can see is that even for people here who are very close to zero risk, the release rate isn't as close to 100% as we would like. And notice also that the vast majority of defendants who go through the pretrial system are super low risk. So a 10% detention rate among the majority of people who are low risk winds up leading to lots and lots of low risk people who are detained every year. And similarly, at the other end of the risk distribution, you can see there are people who have something like a 60% predictable failure rate who wind up getting released at about a 50% rate. So the judges are simultaneously detaining lots of low-risk people and detaining low-risk people and releasing lots of high-risk people. Now, the reason that I think this is so important for policy is a lot of the policy conversation around criminal justice reform in the United States tends to have the flavor of, we can either reform the criminal justice system and reduce the harms that criminal justice imposes on society, or we can keep the public safe, but we can't do both. And what's exciting about recognizing the role of misprediction in the criminal justice system is you can start to see opportunities where you can simultaneously address both sorts of challenges at the same time. So let me just give you a very simple cartoon example. Imagine a world in which we have 4 defendants, 3 low risk, 1 high risk. So we have 3 people in jail at baseline, and 1 high risk person gets released and they commit 15 crimes. So we've got 3 people in jail, 15 crimes at baseline. If we can help judges and prosecutors better predict risk in the system, we have the potential to release all of the low risk people and detain the high risk person. And so if you just think about the math of this super simple example, what we would be doing if we made that 3-for-1 swap is we'd be reducing the jail population from 3 people to just 1. It's a 66% reduction. And we'd be reducing the number of crimes from 15 to 3, 75% reduction, right? Or 80% reduction, excuse me, right? And so this helps you see fixing misprediction gives us opportunities to really get win-win gains in the criminal justice system and get us out of a lot of these sorts of partisan fights that we that dominate so much of the conversation. Now, we know that I would say the main source and the appropriate source of concern with data tools in the criminal justice system is the possibility of bias. And we can see that this is something that's really come to the fore of the public conversation around the idea of using data and data tools to inform criminal justice decisions. And so you can ask yourself, how worried should you be, or should you be worried? And I think what I would say is yes and no. And here's what I mean by that. So, on the one hand, algorithms, unlike people, have no moral compass to try and aspirationally draw themselves back to mitigate bias by themselves, because algorithms are just statistical tools. But on the other side, algorithms, unlike people, also have no intrinsic tastes, including none of the explicit or implicit biases against outgroups that human beings have in abundance, as we know from just looking at the world in a huge body of social science and behavioral science research as well. And what I want to argue is that, and I think that there's evidence to back this up, as I'll show you in a second, that algorithms properly designed can be a real force for social justice. And the properly designed there is a very important part to the story. And I think a theme that's going to come out in this series of conversations that Jen has organized. And so let me just close by showing you the results of some work that my research center here at the University of Chicago did. The Crime Lab, several years ago, we were asked, starting around 2018, we were asked by the city of New York to come in and help them update the data-driven release tool that they were using in their courtrooms. And the previous tool that they had implemented was built in 2003. All right, so just pause for a moment and think about how much New York City changed from 2003 to 2018. It probably goes without saying that it's not ideal to let one of these risk tools just sit there and linger like a zombie for 15 years. So this is what the pattern of recommendations were from the old risk tool applied to 2014 data when we started the project of building the new updated tool. So you can see that a relatively small share of defendants were recommended for release. So that's 0.1 to take from this. And 0.2, you can see that there's a sizable disparity here in the release recommendation rate for Black and white defendants. Okay. And so what happens with the new tool, under the new tool that we built for New York City? I think there are two things to see here. The first thing that we can do is we can dramatically increase the share of people who are recommended for release, because now, as I just illustrated, now with the data tool, we're prioritizing detention just for those people who are actually high risk. Okay, so we can dramatically increase the recommended release rate without crime going up because we're predicting much better and prioritizing jail detention. And the second thing that you can see here is relative to the old tool, now there's effectively no disparity at all in recommended release rates for Black and white defendants in New York. Now, let me just end. So far, this is a remarkably good news story. Let me just close with a bittersweet coda, and then I'll conclude. The bittersweet coda is what happens when you put this new data tool into the hands of judges and prosecutors and other people in the criminal justice system. They take a data tool that's recommending something like 83 or 84% of defendants for release with no disparity, and they turn that into a lower actual release rate and reintroduce disparities between Black and white defendants. Okay, and so when I think about the policy implications here, I think to me the most important are that algorithms have the potential to predict more accurately and get us less crime and less detention simultaneously, and to reduce racial disparities in the criminal justice system. But there is no guarantee, as you'll see in the series, as I mentioned, there's no guarantee that any specific algorithm will reach that potential. An algorithm is not an algorithm is not an algorithm. And an algorithm in the hands of a human is always a wild card because the humans themselves are always wild cards. And as I think one of the key things that we need to be more thoughtful about here, once we recognize that algorithms are very different things, is to develop better systems for procuring and evaluating in advance candidate algorithms before they're taken to scale and implemented and affect hundreds of thousands, if not millions of people coming through the criminal justice system every year. Thanks very much.
Great, thank you, Jens. Megan Stevenson is next.
Hi, everybody. There we go. I think I'm set up and ready to go. So thank you for this opportunity to chat. This is a kind of a nice segue because Jens, showed a lot of what the potential of these algorithms are, and then gave some warning flags at the end that when you give them to human beings, the results might be a little bit different than anticipated. So this paper is going to continue on that theme. And in particular, what I'm going to do is look at what happens when Kentucky adopted the use of risk assessment. In particular, I'm going to evaluate hold on a sec, two different policy changes. One took place in 2011. This is a new law that made pretrial risk assessment mandatory and set a presumptive default of release for defendants ranked low or moderate risk, which wound up being about 80% of all defendants. So that's similar to what Jens just showed, a very large portion of the defendants. And then the second I'm going to evaluate is a switch in 2013 when Kentucky switched from their own kind of homegrown risk assessment to the PSA, which is the risk assessment developed by the Arnold Foundation, and which is now, by far the most widely used pretrial risk assessment in the United States. I can't remember the latest number, but it's dozens and dozens of jurisdictions and many entire states use this risk assessment. All right, so we're looking at Kentucky. Partly I flagged that the PSA is broadly used, but it's not just the PSA; it's the entire way that risk assessment was adopted and incorporated into the pretrial system. That in which Kentucky was really a role model. There's lots of other states that followed the Kentucky model, including California, as you can see by these these quotes that I'm showing up on the board. This was also the model for the bill that Senators Rand and former Senator Harris proposed for reforming pretrial risk assessment. So I think it's very informative, not only on a local sense in terms of Kentucky, but what might be expected to happen in many other jurisdictions as well. All right, so I'm mostly going to be showing you a series of graphs. So let's take a moment and walk through what these graphs are showing so that you can understand them. Right here on the bottom, you can see that this is time. So this is just a trend over time. In particular, this is a trend over time in the likelihood that defendants of different risk categorizations are going to be given non-financial release, basically release without monetary bail. This dotted red line is the date at which this bill, this 2011 bill, the one that made risk assessment mandatory, passed, and this solid red line is the date that it was implemented. It was sort of made mandatory. As you can see, there's some changes that start around the time that it passed, some that really go into effect at the time when it's implemented. Now, up here in the top is this green group is the low risk individuals. And you can see that these low risk individuals, there's a very large likelihood very large increase in the likelihood of being granted non-financial release that comes as a result of this pretrial risk assessment. This red group down here, these are the moderate risk individuals, have a kind of a more moderate increase in release. And for these high risk individuals, there's really no meaningful changes. Now, this is not all releases. This is just release without monetary bail or non-financial release. If you look at the overall likelihood of being released, either by not having to pay money or being able to afford the amount of bail, you see a similar but somewhat more attenuated pattern. These low-risk individuals, if you compare the period right before and right after this reform, there's about an 8 percentage point increase in the likelihood that low-risk individuals will be released, a slightly smaller increase for moderate, a slight decrease in the likelihood that high-risk individuals will be released, and no change for the group of people who, for some administrative reason, failed to get any score. Now, this is the net change in pretrial releases. And once again, this is, this is a time trend. Here is the date that the HB 463, the pretrial risk assessment law, was adopted and implemented. And then over here, we've kind of zoomed out a bit. So we're looking at a longer time period. This is the date at which the PSA was adopted. You can see there's an increase of about 4 percentage points, not a huge one, in the net number of releases. And maybe just a tiny blip up in the likelihood of being released as a result of the PSA. So first thing to take away is that there is not a big change in the release rate, as would be expected if judges had strictly followed the recommendations of release for the 80% of individuals who received one, who are rated low, or moderate risk. There was, they responded, but in many ways they overrode the recommendations of release that were associated with the risk assessment. So we've got a small increase in releases, but unfortunately, we also see a small increase in failures to appear in court. Again, this is not a massive one. This is an increase from about 7.5 percentage points up to maybe 9 percentage points, but an increase nonetheless. Now, this is somewhat mechanical. You release more people, some fraction of them are going to fail to appear in court. But we didn't achieve so far the hoped for gains where you're releasing people without any negative consequences. And once again, no noticeable benefits when the PSA is adopted. So here, this is pretrial rearrest. This is a little bit noisier, and I would say, I wouldn't say that there's any clear evidence that pretrial release increased as a result of risk assessment, but there's definitely no evidence that it decreased, even though there's a reshuffling in who gets incarcerated as aligned with this risk assessment score. We're not seeing any kind of real noticeable benefits either from making the risk assessment mandatory or switching to the PSA. And then finally, this is a graph showing release rates by race. This blue group up here are white defendants. This kind of green or gray line down here is Black defendants. And you can see that it resulted in an increase in racial disparities as well. White defendants benefited a lot more from risk assessment adoption and from the switch to the PSA than did Black defendants. Now, at first glance, this might be something you'd blame on the risk score. Maybe the risk score embeds these racial disparities because of different inputs that might be proxies for race. As it turns out that this is not really the case. The reason that we have this racial disparity, this increase in racial disparity, is because rural, which are mostly white counties, simply responded more. Judges in these rural counties responded more. However, within each county, judges liberalized release similarly across races. So this is a geography story rather than kind of racial disparities in the risk score or racial disparities in the way one particular judge responds to the risk score for people of different races. So just to kind of summarize the takeaway, that with this risk assessment, as is true, I think, with pretty much all policies and all reforms, it's really important to evaluate to see if the impacts are as anticipated. There was a lot of reason I think people were excited about risk assessment, that it had a lot of potential. There were some policy simulations suggesting that very, very large gains could be achieved. But the real world is different from a policy simulation in a variety of different ways. When you give a risk assessment to a judge to make the final decision, which you do almost always in the use of risk assessment, it's very rare to entirely grant the decision to the judge and take human discretion out of it. You're not getting rid of the human. You're still bringing along the human with all of their benefits and all of their faults, all of their, all of the insight that they might have, but also all of the biases and their errors and so on and so forth, and their incentives and so forth. So it's important to evaluate and see if impacts are anticipated, and also to think carefully about how human beings are going to use these algorithms when when you're looking at it in the real world. So thank you so much for the opportunity to chat, and I look forward to hearing more from my other panelists.
Wonderful. Thank you, Megan. Cody Tuttle is next.
Right. Yeah. So hi, I'm Cody Tuttle. First, thanks Jen and the Niskanen Center for organizing this great series and inviting me to be a part of it. I'm going to talk about a project that I worked on that's broadly about racial disparities in federal sentencing, but specifically zooms in and focuses on federal drug mandatory minimums. Before I get into the details, I first want to give some brief motivation for studying these topics. In 2016, federal sentences for Black offenders were 20% higher than federal sentences for white offenders. This is concerning because we think sentencing is costly for people incarcerated. And if there are racial or ethnic disparities in sentencing, then those costs are disproportionately borne by Black and Hispanic offenders. A key question for policy then is whether those disparities are due to observed or unobserved differences by race that exist before a person enters the criminal justice system, or whether they're due to discretion or discrimination by actors in the system itself. Of course, both of these things can be happening at once, and any differences that do exist upon entry could be the result of inequalities in other US institutions. Now, this is a very big question that lots of people have done lots of great work on. I'm going to contribute to this broader question by focusing on federal crack cocaine cases and the application of mandatory minimum sentences. I think this setting is important in its own right. About 20% of all federal drug cases involve a crack cocaine offense, and racial sentencing gaps are particularly large in these cases. In addition, the structure of mandatory minimums and recent changes made to crack cocaine mandatory minimums make it a setting that's interesting and useful in an empirical sense. What I mean by structure is that for federal drug cases, a mandatory minimum sentence is triggered if the offense involves more than a threshold amount of drugs, with the amount involved being subject to prosecutor discretion. A key idea here is that if prosecutors want to maximize sentencing or guarantee some specific sentence, then they can charge offenders just past that threshold. And if they can do that, do they do it differentially by race? I'm going to find that they do. And what I mean when I say changes to crack cocaine mandatory minimums, I'm specifically talking about this change that occurred with the 2010 Fair Sentencing Act. There was a long and well-known policy debate about the disparity between the threshold set for powder cocaine versus the threshold set for crack cocaine, which eventually led to a change in the crack cocaine thresholds in 2010. As part of that change, the 10-year mandatory minimum, which is the highest mandatory minimum for crack cocaine, changed from 50 grams to 280 grams. That change allows me to compare the pre-2010 cases to the post-2010 cases to estimate the concentration, or what I'll call bunching, of cases right above the 280 gram threshold, and the difference in that bunching by race. It also lets me use those pre-2010 cases to test whether those differences are due to differences in underlying drug involvement by race, or differences in prosecutor decisions to bunch a case at 280 conditional on drug involvement. I want to stress that this isn't one drug that I've cherry-picked out of many. This is the only drug for which the mandatory minimum threshold has changed since the implementation of mandatory minimums. So this is the only case where I can use pre-2010 period to show what's happening in the post period. To show you what I mean by bunching, on the left, I'm plotting the distribution of crack cocaine involvement in sentences from 1999 through 2010. This is before the threshold moves to 280 grams, and you can see there are very few cases recorded right above 280 grams. On the right, I'm showing you the distribution of crack cocaine involvement in cases sentenced from 2011 through 2015. This is after the threshold moves to 280 grams, and you can see that there's this big movement of cases right above that 280 gram threshold. That's what I'm referring to as this bunching above the threshold. At this point, you might be wondering, how exactly can prosecutors influence the amount of drugs involved in an offense? This is possible because in federal court, they can introduce more than just physical evidence. They can use witness testimony. They can use the cash the defendant was holding at the time of arrest and convert it to a drug amount. They can tag the defendant with a drug conspiracy charge, in which case they'll be held responsible for the total amount involved in the conspiracy. These are a number of different things that they can do, and these are all at their discretion. This is something prosecutors might want to do because drug amount is directly tied to sentence length. And prosecutors may prefer long sentences for a variety of reasons: career concerns, beliefs about the efficacy of sentencing, or to just use them as tools in plea deals. To show you that this is something that actually happens, here's a quote from an assistant U.S. attorney interviewed by Mona Lynch for her book Hard Bargains, where she says the actual heroin sales directly tied to Mr. Samuels and his son were of 1 gram and 4 grams. The rest was arrived at on the say-so of confidential informants. The assistant U.S. attorney prosecuting the case told me that she could have established enough historical weight through those conspirators she had flipped to get Mr. Samuels to at least a 10-year mandatory minimum sentence. So now that you can see that this is something that prosecutors can do and something that they may want to do, I'll turn to the data. The data that I'm going to use comes from the United States Sentencing Commission. It's the universe of federal drug cases sentenced from 1999 through 2015. And here I'm plotting the fraction of crack cocaine cases recorded in that 280 to 290 gram range in each year. Again, as you can see, prior to 2010, before the threshold is at 280 grams, there are very few cases recorded in that 280 to 290 gram range. After 2010, that jumps up, and specifically it increases by about 3.5 percentage points. That increase is about 3 times larger for Black and Hispanic offenders than it is for white offenders. So that's what I'm referring to when I refer to this racial disparity in bunching above the threshold. In the paper, I do a lot of work to try to understand where these cases are coming from, ultimately finding that these cases that are bunched at 280 grams are likely cases that would have been recorded somewhere from 60 to 279 grams had they been sentenced prior to 2010. So I've shown you this bunching shows up in the final sentencing data, but how do we know it's a result of prosecutor decisions? What I do in the paper is use a variety of data sources to show that this only arises once the case is in the hands of the prosecutor. There's no change in self-reported drug use or selling post-2010, no change in amounts recorded in state or local cases, and no change in drug seizure amounts from federal or local police. But there is this increase in bunching in prosecutor case files from the Executive Office of the U.S. Attorney, and then subsequently in that final sentencing data from the USSC. So we see this increase in bunching for all offenders. We see a racial disparity in that increase, and this is something that's a result of prosecutor decisions. But that racial disparity could be due to one of 2 things. It could be that there's a difference in underlying drug involvement by race, or it could be that there's differential treatment by race, a difference in prosecutor decisions to bunch a case conditional on drug involvement. This is where I can use those pre-2010 cases to try to understand which of these explanations is at work. Again, I do a few different tests related to this in the paper, but here what I'm showing you is the distribution of charged amounts by race for cases sentenced prior to 2010 for that range of 60 to 279 grams, since these are the cases that are at risk of being moved to 280 grams. What you can see is that these distributions are very similar by race. So if you had in mind that perhaps Black and Hispanic offenders were just more likely to be involved with these higher amounts, that's not what's going on here. So now I've made the case to you that these racial differences in bunching are not reflective of racial differences in drug involvement. A separate question is whether these racial differences that exist conditional on drug involvement are driven by some factor correlated with race rather than race itself. So using the final sentencing data, I can show that there's little change in this disparity after controlling for a host of defendant characteristics. I can also look at the interaction between race and all of those characteristics and still see that there's a racial disparity even within all of those observably similar groups. Even if I look more closely at that criminal history score variable and compare defendants with more similar criminal histories, you still see that this bunching exists within all of those groups. I want to end with an analysis of a Supreme Court case in 2013, Elaine versus US, that decided because mandatory minimum sentences increase the penalty for a crime, any fact that increases the mandatory minimum is an element of the crime that must be submitted to a jury. Effectively, what this does is increase the evidentiary standard in these cases. And what I see is that bunching peaks in 2013, and it's been falling ever since. And if I compare cases filed close to the date of that case, I see a drop in bunching right after the decision in Elaine, which suggests that those bunch cases are reliant on relatively weak evidence because they're responding to this increase in evidentiary standards. I highlight this last because I think this also shows that we can place effective limits on prosecutor discretion, in this case, reining it in with these increased evidentiary standards. So what can we take away from all of this? In 2010, we see this shift to 280 grams for the threshold. At the same time, we see this big rise in cases recorded right above 280 grams. That increase is much larger for Black and Hispanic offenders, and it's not driven by differences in drug involvement. I think this is a clear example of how prosecutor decisions interact with policy, in this case, ultimately dampening the intended effects of the Fair Sentencing Act. And so in terms of policy takeaways, I think this highlights that, if we have a policy that is going to make sentencing more relaxed or more strict or change the rules of the game in some way, we really need to consider how courtroom actors will respond to that policy and whether those responses will counteract some of the policy goals. Ultimately, the bunching at the 10-year mandatory minimum alone can explain 7% of the racial sentencing gap in crack cocaine cases post-2010. This goes back to that motivating question of whether racial disparities in sentencing are explained by differences before someone gets to the justice system or explained by differences in treatment once they're in the system. This would suggest they're partly due to differences in treatment once they're in the system. Prosecutors have a great deal of discretion and they can use it in racially disparate ways. So a very important policy question is how we can rein this in. In this case, evidentiary standards played an important role. But again, once we start thinking about broader policy shifts, I want to emphasize that first point that we really need to think carefully about the range of possible responses from courtroom actors and whether those responses will be in line with policy goals. So that is all I have. Thank you very much.
Thank you, Cody. And last but not least for today is Allison Stashko.
Okay, great. Oops. Sorry. Okay, great. So thank you so much. It's really great to be on this panel. My name is Allison, and I'm presenting work which is ongoing and joint with Ari Scaro. And what we're interested in broadly is how changes in the prosecutor's office can affect policing behavior. So as a starting point, we know that prosecutors and police work together very closely to enforce the law. And so this has raised concerns about conflicts of interest when a prosecutor is responsible for investigating a member of the police department in their own district. And this question is especially important in cases when an officer is being investigated for the death of a civilian. So this is where the debate has really focused on in recent years. And that in itself, whether or not the local prosecutor should handle those types of cases is an important criminal justice question. But separately and relatedly, we're interested in whether these working relationships that might give rise to conflicts of interest can also affect police behavior even before an incident occurs. So the reasoning there is that if an officer anticipates that they have a low likelihood of being indicted, or they have some perceptions about how the investigation might unfold, they might be willing to engage in somewhat more risky behavior than if they had no close relationship with the prosecutor. And so one way to understand if that's actually playing out in the real world and in the data is to ask, well, what happens when a new prosecutor takes over? And so in this study in particular, we ask what happens to the number of people who are killed by police after a new prosecutor is elected to office. And so just to think more carefully about why we think that this important policing outcome might actually be influenced by changes in the prosecutor's office, the first idea is this story that led us to this question about the potential for conflicts of interest, where a new prosecutor marks the end of an existing relationship with the incumbent prosecutor. And so to the extent that that relationship was perceived as protective by police officers, it could mark a sort of sea change in attitudes and behaviors of police. And so we're not necessarily thinking that police officers are recalling recent changes in the prosecutor's office in the moment of these high stakes decisions about whether or not to use force, but more that there's a big sea change in the prosecutor's office, and that could trickle throughout law enforcement and maybe even into the behavior of police officers. Alternatively, though, it could be that a new prosecutor has incentives to establish a really good relationship now that they're in office. And so that could be perceived as a force that goes in the other direction, where police actually expect that they are even less likely to be indicted and maybe take on more risky behavior. Alternatively, even if there were no conflicts of interest, so all of these investigations are happening as if it was any other civilian when a police officer is involved, the fact that police officers don't know this new prosecutor could introduce greater uncertainty. And we think that people behave more cautiously when they are faced with a sudden increase in uncertainty over what might happen in future investigations. And then last, we're here to discuss prosecutorial policy change. And so it could be that the new prosecutor introduces an agenda which is specifically aimed at holding police accountable. And this has been a platform that has gained popularity in recent years and during our study period. So in this study, we'll be thinking about these different stories or mechanisms to see what holds up in the data. So to study this question, we need two important pieces of information. One is election outcomes. We look at all of the prosecutors who were elected between 2013 and 2017. And then we observe the number of people who are killed by police in each state prosecutor or district attorney's district from mapping police violence. So our approach here is something known as differences in differences. And the intuitive idea is we want to compare what happens within a district to the number of people killed by police after the election versus before. And in districts where a new DA won versus where the incumbent or the existing prosecutor remains in office. So in this way, districts that get a new DA are like a treatment group, and districts that re-elect the old DA are like a control group. We want to make sure that our treatment and control groups are comparable. And we think that one reasonable way to do that is to focus on districts that have a competitive or close election. So we're in our preferred estimates only comparing those districts where a DA narrowly defeated an incumbent versus districts where an incumbent narrowly defeated a challenger. And so in that way, we're selecting districts that are perhaps more comparable because they have competitive elections. And so you're getting more similar prosecutor offices with similar amounts of resources and caseloads and so on. So these are our results. Here I'm plotting for you the estimated effect of a new DA on the number of people killed by police per district per year. And so a dot represents the actual estimated effect, and I'm varying the sample as you move across. So all the way on the left-hand side is the sample of really close elections. And this tells us that when a new DA takes over, there are 0.3 fewer deaths in the years following the election every year. And that amounts to a 42% reduction in the number of deaths. The lines indicate how precise these estimates are. And as we move across, we're just expanding the sample all the way until you get to the full sample on the right. So the takeaway of this figure is that no matter how we slice the sample, we consistently see that there's a statistically significant negative effect on the number of people killed by police. We do get a more conservative point estimate when we look at the full sample, something like 17% reduction in the number of people killed by police. So again, it's always a sizable reduction in the number of deaths that are reduced after a new DA takes over relative to the places where the incumbent stayed in office. If we break this down by subcategories of events, we can look at the number of deaths by race and ethnicity and by gender. Because we're looking at more specific types of events, so this is the death of a white individual versus a Black individual, we lose some precision. And so a takeaway here is we don't see that this is only driven by one type of incident and that the point estimates are fairly similar, at least when you look across race and ethnicity. Okay. The last thing I want to tell you about is other law enforcement outcomes and how they respond to what a new DA winning a close election. And we think that this shines light on exactly how police officers are changing their behavior. So if we look at what happens to arrests and crime after a new DA takes over, we don't see any significant changes. And we see this as consistent with a story where police officers are not avoiding situations that could turn violent, because in that case, we might expect fewer arrests and or more crimes. But because we don't see that, we think the evidence is consistent with police officers being able to de-escalate situations that otherwise would turn violent after a new DA takes over. Last, it's important to know if officers are at greater risk themselves because they're using fatal force less frequently, but we don't see any increase in the number of officers assaulted or killed in districts that get a new DA versus the ones that keep the old DA. When we ask which prosecutors are driving these results, is it the agenda or conflicts of interest or uncertainty? We have some mixed results. So this is an ongoing area of the study where we're trying to collect more data to learn about specific prosecutor policies. So far, we do see that the effect is slightly larger when a progressive DA wins versus when someone who is unlikely to have a progressive platform wins. But what's interesting is that you still see a significant negative effect even in districts that are strong Republican or where a nonpartisan is elected as a prosecutor. And so it doesn't seem to be something which is only driven by the agenda of progressive or reform-minded prosecutors. So to summarize, we do find that after a new DA is elected, there are fewer deaths caused by police. The magnitude of this effect is quite sizable, especially if you think of other things that people have studied to try to reduce the number of people killed by police. And so in one back of the envelope example, we can estimate that given the number of new DAs who were elected in 2016, our estimates would imply that there were between 2 and 7% fewer deaths that year due to the turnover in prosecutors' offices. So what can we make of this in terms of ideas for reform? One thing that kind of surprised us is that it's not just about progressive DAs, but it turns out that turnover in general seems to have this effect on police officers where they begin to behave more cautiously in terms of use of force. And so you might think then that a solution here, if your goal is to reduce the number of deaths, is just to put term limits or reduce the length of time that a prosecutor is in office. But we stopped short of recommending that because, of course, a good working relationship between prosecutors and police has other benefits in law enforcement. It's just that it seems that the conflicts of interest and the uncertainty mechanisms are at play here. And so maybe instead we can simulate that or have a similar effect if prosecutors commit to bringing in outside investigators for cases that involve police officers. So although our paper doesn't directly recommend this policy because we don't study it, it's exciting to know that other districts are adopting these types of policies, which gives us an opportunity to evaluate them down the road and learn if police are behaving in similar ways in districts that use outside investigators for their cases. Thanks very much.
Great, thank you, Allison. Okay, thank you to all of our panelists for staying on time. We're finishing before the end of the hour. Thanks again for all the great presentations. Thank you to everyone who was here to watch them. I believe everything's being posted online in a day or two, so you can go back and rewatch your favorites. And we'll be here at the same time next week for another set of panelists. So you can register the same place you registered for this webinar. So I will see you then. Thanks, everybody.